Let's start. So welcome today to this seminar, which is co-hosted by the Melbourne Climate Futures and the Asian Law Centre. I'm Sarah Biddulph. First, I'd like to acknowledge country, that we are having this meeting on the unceded lands of the Wurundjeri people of the Kulin Nations, and I pay my respect to their elders, past, present and emerging, and extend our respects to any Indigenous people who are in this meeting virtually or in the room. Thank you. So today it is my great pleasure to introduce to you Dr. Ekaterina Aristova, who is a Leverhulme Early Career Fellow at the Bonavero Institute of Human Rights at Oxford. And she has travelled very far to come today to give this presentation. So Ekaterina is a research fellow at the Bonavero Institute of Human Rights in the Faculty of Law at the University of Oxford. And her research interests are in the field of business and human rights, and a particular focus on strategic human rights and environmental litigation. So she examines how conventional private law doctrines evolve in response to global challenges and are used creatively in different jurisdictions to foster human rights and environmental accountability. So Ekaterina is already very well published. She's co-editor of a book, Civil Remedies and Human Rights in Flux, published by Hart in 2022. Yes, please be careful when you step over that. Yes. It's a trip hazard and all sorts of other hazards. Are you right there? Sorry, big step. Okay, yeah. She's author of a forthcoming book, which is due to be published on the 25th of April this year, Tort Litigation Against Transnational Corporations in the English Courts, The Challenge of Jurisdiction, to be published by Oxford University Press. And this is a revised version of her PhD thesis published, or which was completed in 2022 at Cambridge University. So Ekaterina has been awarded the prestigious Leverhulme Early Career Fellowship to complete a project on climate change litigation against corporations. And that is the topic of her talk today. The arrangement is that I'll invite you now to speak for about 25 minutes. We'll have plenty of opportunity for questions and discussion. And for anybody who's online, would you please put your questions in the Q&A box, and I'll be monitoring that and give those virtual people an opportunity to ask questions as well. So thank you very much, Ekaterina.
Thank you very much, Sarah, and thank you very much for having me. It's a great pleasure to be here. And it's a great honor to share some of the results of my research findings. Sarah already did a great introduction. I'm a business and human rights expert, lawyer, academic. I'm based at the Bonavero Institute of Human Rights, which is a dedicated institute within the Faculty of Law in Oxford. And my colleagues run a number of research projects and student programs in the broader fields of democracy, rule of law, and human rights. And I'm leading research on business and human rights, which means that in my everyday life, I'm looking at how corporations should be held accountable for the adverse impacts of their operations under national law, international law, or other quasi-international instruments. And my latest project is about corporate climate litigation, which is a big trend, big phenomenon happening. And I can't think about any better place to present this research as in Australia, which is obviously leading its way in climate change, tackling climate change. And there are so many interesting cases happening here. So I'm looking forward to both sharing with you some of the things that I've been thinking about, but also learning from you about some of the perspectives I can incorporate in my work and in my research. So I'll talk today a little bit about generally what's going on, how many cases we are talking about, what these cases are about, and I will talk also about the case that has been quite high profile in England. This is a case against board of directors of Shell as an example of the novel claims that are happening in these areas, and also talk a little bit about the insights and directions for further research. But I just want to start with saying that I'm not a climate change lawyer. Sarah already mentioned some of the work I've been working on, and I'm looking at how private law in particular is responding to some of the novel challenges that our society is facing today, whether it's climate change and pollution, or it's rise of multinational companies, artificial intelligence. So how private international law, tort law, company law have dealt with those issues and used some of the conventional theories to tackle these globalized challenges. And it became quite obvious over the last few years while I was doing my research that climate change litigation is becoming a big thing. And obviously, this is one of the biggest challenges we face, one of the big crises that we face. And until recently, climate change litigation focused exclusively on the responsibilities of states as major players. But advancement in science, policy drivers have also put the focus on corporations, in particular big fossil fuel companies. What about their responsibility? So my project looks at climate change litigation more generally. I have been doing this research for just over 1.5 years. And the idea is look at particularly private claims. But as a starting point, when I just started doing this research, I thought, well, I need to figure out what's going on, how many cases there are. And it's a not easy question to answer because it depends on how we define climate change litigation. And there are multiple definitions that have been offered by experts. I'm relying very much on the database that is run by the Sabin Center of Climate Change Law in US, who define climate change litigation as lawsuits that deal with climate change law, policy, or science. And as of 20 March 2024, Sabin Center recorded 192 cases involving corporations outside the US. This is the way they run their database. They have two separates. One focuses on the US exclusively, one on non-US litigation. US is a different universe, so I won't talk much about it today. I will focus mainly on what's been happening outside the US. So these 192 cases have been recorded in 28 jurisdictions, which is quite an impressive number, given also that we're not only talking about global north jurisdictions where business and human rights litigation has been traditionally happening, but also a wide range of jurisdictions all over the world. And these cases also happening in different fora. So it's not just judicial system and national courts, but also state non-judicial mechanisms, for example, competition authorities or human rights commissions, but also quasi-judicial bodies such as national contact points, which are established by states under OECD guidelines for multinational enterprises. So this number, 192 cases, is not complete because obviously there are difficulties in recording cases, especially if we're speaking about jurisdictions where language can be an issue. So this number is likely higher, but at least major high-profile cases are there. There are different ways to categorize this climate litigation. So what I've done next as my part of my research is I looked through all of these 192 cases. The Sabin database has a great way of summarizing what this case is about. And for some cases, looked also at the documents that are attached, whether these are claims that are brought by litigants themselves or judicial decisions. And there are different ways to tell a story about what this case is about. So I've put some of the different types, how experts categorize them. It's either focusing on impact, for example, strategic, non-strategic litigation. Strategic lawsuits are usually those lawsuits that are aimed at making an impact beyond one case and drive broader social change. There are also cases based on the novelty of the argument, and next generation cases are particularly interesting for many of us because they try to introduce a completely new accountability model where corporations or states can be held accountable for the direct impacts of their operations on climate change. Type of climate action, causes of actions, also role of the climate-related concerns, whether it's all about climate change or climate change could be a minor issue in the case, and the case could be mostly about environmental pollution, for example, but also legal strategy. And this last category is particularly interesting for me. It's been introduced by London School of Economics, who published Grantham Institute of Climate Change Law, who publish annual reports about the status of litigation all over the world. These annual reports usually come out in June, and they do categorize these cases based on the legal strategies. So it's quite difficult actually to put cases in these categories, particularly because sometimes the cases happen at the edges of categories, but also using different legal bases to achieve the same outcome, for example. And also jurisdictions themselves quite different in how they define elements of liability. So in one jurisdiction, one case can fall in one category, in another jurisdiction in another. But it's nevertheless, I think, an important exercise to try to systemize this, just to understand what are we learning throughout this litigation from these cases, also analyze motivation behind the cases and some comparative insights. So I'm trying to work at the moment, one of the articles I'm working on is trying to suggest an alternative way to categorize corporate climate cases by focusing on the subject matter of the case, in a way on the legal strategy as well. So what are the claimants actually trying to achieve? What do they want? What is the intended outcome? And this article is meant to have a broader audience of people who myself are not necessarily climate change lawyers or climate change experts per se, but they're interested in this litigation and they're studying it as part of the broader field. So I identified several, 6 categories in particular, and just go very briefly through them. So the first, probably most numerous category, are those challenges that focus on individual high-emitting projects, and claimants try to challenge the project itself, whether it will be opening of the new coal mine or a new fossil fuel investment. And I've identified 2 streams of cases in this category. The first one, most numerous, and what is called first-generation lawsuits, are administrative challenges to government decision-making. And it's usually challenging the permit or environmental assessment. Usually the government will be the main defendant as a decision-maker, and the corporation will be a second respondent as the one which implements the project. And the first ever case recorded in this category is an Australian case against Redbank Power, which was brought in 1994. In this category, I've also identified subcategory B, which is also cases that challenge individual projects, but they go beyond procedural aspects. They're trying to have a bit more sophisticated argument where they try the aim is to seize those emissions intensive projects, but on the grounds that could, for example, combine different arguments like violation of human rights. And there are interesting cases in Japan happening on these grounds, but also the case in Australia, Youth Verdict versus Varata Coal, which is the case to an objection to the proposed coal project in Queensland on human rights ground, whether to issue the mining of the lease and environmental permit. So these are the projects about individual cases about individual projects. The second categories are more ambitious cases which go beyond individual projects and try to compel companies to change their business model as such. So they are not only focusing on particular investments, but on the wide policy of the group, and compel companies to reduce emissions by making changes to the way they run business as usual. Probably the most famous case in this category is a case against Shell in the Netherlands, which was brought by environmental organization called Milieudefensie, trying to establish that Shell has a duty of care under Dutch civil code to take an action to reduce emissions. The case was successful in the first instance when in May 2021, the court ruled that Shell has to take an action to reduce emissions by 45% by 2030. Of course, Shell appealed this ruling, and the appeal hearing started last week, which is quite exciting. That is going on right now. Shell's main defense is that, first of all, those targets have been set for the states, and you can't make a corporation to comply with a target which aim in public actor. But the second major defense, among few others, is what we call market substitution defense. Shell is trying to say that if it's not us, there will be another company that will be trying to implement same projects in the oil extraction, and it will cause emissions anyway. So if you have to punish corporations, you have to do it via legislation and punish everyone, not just us. Shell case was reproduced in several jurisdictions, including in Germany, so far unsuccessfully. There is also a case in Italy, which is mirroring Shell argument. And an interesting pattern in this second category is going beyond corporations as defendants, also tackling banks. So it's also a corporate entity, but going beyond fossil fuel companies, but tackling banks for the way they invest and trying to compel them align their investment portfolio with the Paris Agreement and reduction targets. Third category of cases, those that are focused on remediation of climate change related damages. So these are monetary claims. Probably the most interesting cases are in subcategory A, which are exclusively climate change cases trying to establish liability for harms arising from warming effects of climate change. And it's both for future damage, but also past damage. A case against RWE in Germany, which was brought by a Peruvian farmer who is living in a small city near the mountains, and up the mountains there is a lake which forms from melting of the glaciers, and the lake is growing from year to year. So soon it will get on the city where this community of Peruvian citizens live, and they're facing a threat of flooding. And what they're trying to establish that RWE, as one of the largest contributors to the emissions, is responsible for global warming, and they have to share their portion of cost that is required to respond to this threat of flooding. But there are also cases in these categories that relate to the damage that has already happened. For example, 4 islanders of Paris versus Helsinki, a case in Switzerland, which relates to the damage suffered as a result of flooding by those islanders in Indonesia. The second category in this group are cases which require compensation for alleged environmental damage in a broader way. Climate change impacts is a small element of that, and they result from specific activities. For example, there are cases in Brazil which are brought against airline companies, and they try to mitigate the damage that is caused by the planes landing and just operating takeoff and landing. So it's broad environmental argument, and climate change is a small one. There are also deforestation cases here, for example. The fourth category are cases against greenwashing cases, which focus on misleading advertising and consumer protection, and they relate to both some broader net zero statements made by corporations, but also some misleading communications about product attributes, whether products are green or good for environment or sustainable. I'm sure we've all seen those statements in the packages, and that's not always that the corporations actually is able to support those statements. So that's what litigants are challenging in the courts. The fifth category are cases against companies and directors of companies that demand transparency in relation to the financial and liability risks that businesses face because of climate change. And then the sixth category are cases, human rights due diligence cases under the French duty of vigilance law, which is quite unique piece of legislation. In 2017, France adopted the first ever type of legislation asking large companies to adopt vigilance plans and to addressing these vigilance plans, any human rights and environmental impacts that arise in the operations of those companies and their supply chains, but also tell how they're implementing due diligence procedures to prevent those risks. And there have been a number of cases ever since. The law is supported by civil enforcement, so there is a possibility to bring a civil case for the violation of vigilance procedures. And there have been a number of cases going on in France, including under climate change law. So this is the bigger picture of what these cases are about. Some of the trends and patterns that I can see, case numbers continue to grow. Still, litigation against states, public litigation, it's much wider, and we're speaking about different numbers, but we can see probably every month there are at least 2 or 3 new cases that have been publicized involving corporate actors. Litigation against corporations is spreading geographically in the jurisdictions that haven't been the focus of close attention of business and human rights before. It's driven very much by individuals and civil society organizations and the voice of of the indigenous communities is very strong, particularly in Australia, where we see few cases representing First Nations and trying to incorporate some of the traditional knowledge in these cases. Litigation targets a diverse range of corporate defendants. It all started with carbon majors, so companies that are heavily invested in fossil fuels, but we can now see financial institutions, airlines, many other companies that face claims, especially when it comes to greenwashing cases. Lots of companies issue various types of products. There are multiple driving forces, including successful strategic cases against the governments, but also science is driving very much this litigation, some new laws, including at the international level. And what I'm probably most interested is to see how lawyers have been very creative about trying to adjust the conventional legal basis and trying to incorporate some of the legal arguments based on the Paris Agreement, interplay between human rights and business responsibility in this litigation. But also there are very novel causes of actions, and some of the cases that we haven't seen before that are emergent. And one of these cases that we've seen in England is the case brought by environmental organization Client Earth versus Shell's board of directors. So it's targeting 11 directors of Shell. It was brought in 2023. Client Earth is a minority shareholder. It's holding a tiny share in Shell, but it was sufficient to bring this case. And I'm working at the moment on one of the articles which has been submitted last month to one of the journals, just talking about this case because it has been already decided, and I'll tell you a little bit at the moment about it. And one of the co-authors with me is also in the room, Lionel, who's an English barrister. So if you have any questions about it, later on, we can both answer. So the essence of the claim is the central allegation is Client Earth is not happy with the energy transition strategy that Shell adopted, but they're targeting not Shell itself as a company. They're bringing a derivative claim against directors, saying, well, it's the responsibility of the directors to adopt an adequate strategy. And by not adopting this adequate strategy, the board is violating its legal duties under Companies Act 2006 in England. The two sections of the Act that are particular interest is Section 172, which is a duty to promote success of the company, and then Section 174 is a duty to exercise reasonable care, skill, and diligence. Derivative claims follow two-stage process in England. The first stage is, in a way, the court acts as a goalkeeper. They need to get out of the abusive or unreasonable claims so that they don't make the company and the director to protect themselves from these unreasonable claims. So in the first stage, the court filters these cases that do not disclose what they call prima facie or arguable case. And it's usually on paper, there is no hearing and just looking at the documents. But then at the second stage, the court hears all interested parties. If they felt that the first stage is fulfilled, they will proceed to the second stage. There is an important aspect of it that the company is generally does not require to participate in the first stage, so that it's not spending resources on these claims that can be unreasonable. Company can choose to voluntarily participate and make submissions, but it can't claim to recover the cost. So it's doing it on its own voluntary basis. And that's important because Client F failed to establish the case on the first stage. On 12th of May, the High Court first dismissed the claim on the papers. Client F applied to have a hearing. There was a hearing on 24th of July, again dismissed. And then Shell chose to participate voluntarily. They were not meant to have any costs being paid, but they still applied to the High Court. And an unprecedented move, and I just want to put it because it's quite important, that Client Earth was ordered to pay Shell's cost of participating in the proceedings. And you probably know that England litigation and the costs can be very high. So the number was not disclosed, but we do know that we're speaking about potentially a few £1 million. So for Client Earth, which is environmental organizations, to pay several £1 million on a quite novel claim, that could be a quite big deal. So why the case was dismissed? Existing case law, and I won't go into much of the detail, but I'll just say that the courts generally in England, they try not to get into the management. They leave the managerial decisions to the directors. And what they require is really a proof of clearly dishonest conduct by the directors, that they manipulated in some way the information or misled the shareholders. But in the Client Earth case, what the High Court said is like, well, Client Earth and directors clearly disagree about the way the climate change must be tackled. But it doesn't mean that directors are not fulfilling their duties, because they do have a strategy. They put the strategy on the general shareholders meeting. They invited some experts to contribute. Because they've chosen the way that Client Earth is not happy with, does not automatically mean that it was a breach. But what is important is that director said that he was the court was very critical about Client Earth motives of bringing this case. And they said that, well, the Client Earth was trying to advance its own policy agenda, that the case was not being brought in good faith. The reason that they want to do it is just to attract some attention, etc. So if you're a company lawyer, company academic, you probably won't be surprised by the outcome of this decision, that it was really pushing the boundaries of company law too far. But if you're like myself, somebody who is involved in strategic litigation for quite a while, you would be surprised by this statement, because strategic litigation always has some sort of a motive of attracting and pursuing public agenda. And Client Earth, as a company that has in its focus in its public documents the purpose of tackling environmental problems, is doing it by all means that are available to them. Sometimes it's working on the law, sometimes it's lobbying new regulations, but sometimes it's bringing a case within an avenue. But the important bit of this case is that we don't know whether the courts will now look at this course decision as a precedent. And it might mean that environmental organizations who want to pursue similar strategic litigation are in danger of having a threat of facing similar outcomes and having to pay the cost of the corporations, which can, of course, have a negative impact on that. So I have a few minutes just to finish. And what I would say is that in November 2023, I organized a workshop in Oxford on strategic climate litigation in Europe. We brought together about 50 experts, including academic, but also litigators themselves who have been working on some of the cases, scientists, anthropologists. And we talked about what are these legal strategies that have been pursued, what is working, what is not working, what we still need to incorporate. We published a report on 5th of March, which includes 16 contributions from the participants. Funny enough, actually, it says climate litigation in Europe, but we have 3 Australians on these photos who are practicing in England. So we have heavily relied on the Australian knowledge and knowledge sharing. What we did in that report, we identified 10 areas, 10 key insights and directions for future research. I know my time is expiring, so probably I will
finish. That's all right.
So I'll say, so those 10 where we have some gaps and where we need further research. Going very quickly, choice of terminology. It has been said that there is a lot of focus on strategic litigation, which usually high-profile litigation, which can be very subjective. What is high-profile? Who decides what is a landmark case? And also, strategic litigation can't always capture some of the cases, biodiversity, ocean pollution, etc. So some work has to be done on non-strategic cases, which could be equally important in that. Second, impact of corporate climate litigation. How do we define impact? Because different actors involved can have different understanding of what is successful case, whether it's just a victory in court or something else. Giving voice to vulnerable community, indigenous groups is quite important. Again, sometimes cases are framed in a way that will be successful in a case, but it doesn't necessarily mean that's what the best for the community. And also indigenous community, quite often the damage that that they are facing can't be translated in monetary compensation. Enhancing expertise in climate litigation, and that can be different aspects. Lawyers who are litigating, what is conscious climate lawyering? How do we represent the clients with an expertise? Universities, how to integrate this climate change and environmental issues in our curriculum, but also judges. Sometimes judges are criticized for being conservative and dismissing cases. And there has been some of the discussion, well, maybe some judges just don't have this expertise to decide the cases that they're facing. How do we resolve that? Legal transplants to climate litigation, whether you can take a successful case and litigate it in the different jurisdictions. And for obvious reasons, we talked about that it's not simply a copy-paste exercise. You have to think about the different jurisdictions. Pursuing novel claims like Client F versus Shell can be interesting, testing grounds, but also can have some unintended consequences about closing the door to some of the cases. Interplay between international and domestic law. Tomorrow, we are expecting decision of the European Court on Human Rights in 3 climate change cases. So that will certainly be interesting, and we'll see how the court responds. Integrating government framework cases and domestic policies. We've been talking about that there is so much litigation that's happening, but at some point we should go beyond litigation and think about enforcement of this and how the cases are actually integrated in the law. Mandatory human rights and environmental due diligence, a trend in Europe that is happening at the moment. Happy to talk about it a bit later. And then unintended consequences of climate litigation, that yes, it's about awareness, yes, about bringing change, but it also can have some adverse impacts, either costs or polarization in the society or few others. And I'll stop here and let Sarah lead the Q&A. Thank you.
Thank you. Thank you. I'm sure that there are a lot of questions, and thank you for a magnificent presentation. You know, so much material so clearly and so quickly. Just let me remind you that this session is being recorded. If you would like to ask a question that is not going to be recorded, please let us know before you speak so that we can arrange to turn off the recording while that conversation takes place. We have 2 questions at the moment in the room. I have 1 online. So let's first, and could you please, if you're happy, to identify yourself when you ask the question. Please keep your question short, and I'm trying to avoid sort of a long discursive type of statement. Please address the question to Ekaterina.
Thank you. My name is Edward. In answering the question, against the climate change, when you look at the big picture, aren't we all paying for it eventually? Because whether the litigation is successful or not, the company will simply raise the prices. So ultimately, aren't we all paying for it? Thank you.
Thank you.
Some of the cases are about payment, about climate damages, but most of the cases are also just not about payment. They do have a different remedy, whether it be an injunctive relief, for example, making companies to adopt policies that have some future impact and forward-looking statements. Some companies, if you talk about greenwashing, for example, if the company is making a statement about clean product or green product, it would be effectively to change this or to explain how they make it. So climate litigation involving corporation is still in its infancy, I would be saying, and litigants are testing different grounds, different arguments. A lot of cases are still going on, and we either have just the first instance or only the submission itself. So it's kind of hard to say about the impact and to say, well, is it working? Is it not working? But I think your question is excellent, and it's sometimes not just about money, about monetary, but about actually changing the pattern and making some bigger effect. And I think it's quite important to understand that in a big picture, litigation is a very small part of what is going on. There are attempts at the international level, there are attempts to tackle states, there is legislation itself, there are some regulatory initiatives that are going outside the law, just on the agreements between the communities and corporations to do something. So it's all part of it contributing, and litigation certainly on its own will not save climate, as it will not save human rights discuss per se. It has an important impact, but its impact is also quite limited as well.
Yeah, at the risk of sounding irreverent, it seems to me that corporate climate litigation is fiddling while Rome burns. Climate justice activists argue system change, not climate change. And it seems to me that we're now at the juncture that we need to transcend global capitalism. Now, that's not a discussion that's often entertained, particularly within the guise of corporate universities. But perhaps what we need to really talk about, and not that it's going to be achieved anytime soon, ever, are deep alternatives like eco-socialism, eco-anarchism, degrowth, even indigenous perspectives. So I'm a little, we've tried to tweak capitalism for a long time, and it isn't working.
Thank you. I'll give you a chance to, we have a question online and then next. Thank you. Yes, please.
Yes, it's a valid question. There is a lot of discussion in my area in the business and human rights along these lines. A lot of focus lately has been either on litigation or on this human rights due diligence. So in particular, doctrinal law, there has been also debate about international treaty on business and human rights, and it's under negotiation in the UN, but has been proven to be politically unsuccessful instrument. But in any case, there is also quite strong voice of some of my colleagues and academics who say that, well, just those measures at the legislative level, some cases, or the treaty, they will not solve on its own the issue unless we talk about the business model as such and the purpose of the corporation. So there is some of the debate along this normative grounds. Well, we need to redefine what is the purpose of the corporation in this at the moment and how it works with the current globalized challenges that we face, and that some of the types of the activities, of business activities, they're just not sustainable. If you're talking about deforestation, for example, in Amazonia, none of the cases will resolve it on its own. The law will not resolve it on its own. Some of the projects just need to be banned completely if we want to have a difference. So yes, it's the big question, but I probably agree with you that it's a long journey. It's not definitely a sprint, it's a marathon. And I think that what litigation is doing is incorporating some of the thinking in the legal system, and it makes at least judges familiar with some of the issues they're facing and trying to incorporate this thinking in the usual decision making and some of the judicial reason. But it's certainly a very tiny step-by-step process.
Thank you. Now we have one question here. Would you like to? Okay. So here, wait for the microphone. And then I have two online questions which have come, and then you're after that, and then you're next. Okay.
Yeah, thank you for your presentation. I've got a question around directors' duties coming out of the Shower case. Do you see there being any sort of like liability or litigation risk for directors who are signing off on disclosures made in financial and non-financial statements that could be categorized as greenwashing, and they're signing off on those statements? Do you see there being any sort of liability, personal director, like breach of director duties, liability risk in that?
That's an interesting question. I think that's also a broader question about whether you can make not just directors, but also corporations liable for the disclosure. And that debate has been happening not just about the climate change, but some other jurisdictions. So what Australia will be familiar with, the Australian Modern Slavery Act, which was enacted several years ago. In the UK, we also have this act. And in UK in particular, this act was called Tiger Without a Teeth, because what corporation has to do, it has to issue a modern slavery statement annually and disclose if there are any risks or any issues about it. But the compliance is very simple. There are only three elements you need to comply with. The director needs to sign it. It needs to be approved by the management body, and it needs to be on the website. So technically, if the company complies with this formal requirements, but says in the statements, well, yes, we are aware there is modern slavery in our supply chain, but we're not going to do anything with that, it will be still complying with that, and you can't possibly bring an action. against it. But it has been a lot of discussion among litigators as well, whether you can sort of, even though there is no enforcement mechanism in the act itself, can you bring a normal, conventional, traditional civil action for this violation, breach of the statutory requirement? We are yet to see these actions, both either in UK or in Australia, but I know colleagues who have been brainstorming about it, and potentially that thinking could be applied to disclosure of the climate sensitive information, because lots of corporations do it voluntary, some do it because it's a requirement of stock exchanges or part of the annual corporate statements. I think there is definitely a way to talk about it, but whether it can happen in the near future is yet to be seen.
I have two online questions now. I might read both of them
Yeah.
to you because I think there's a degree of overlap maybe with your question. So the first question is, do you have any thoughts on the future of tort-based claims in common law countries? In particular, how have you found the approach of courts, for example, in the UK and Australia, to these types of civil liability cases in contrast to similar claims in civil jurisdictions in the EU and elsewhere? So that's the first question. The second question is, you mentioned that in the court in Client Earth versus Shell, the court noted that Shell had instigated policies and business plans in response to climate change, but that Client Earth and the court lacked authority to adjudicate the merits of such plans. I'm wondering whether the court paid it consideration as to whether Shell's board of directors had fully and properly considered the risks of climate change in designing those policies, and whether the court could determine if a board had paid inadequate consideration to such risks and breached their duties of due care, skill and diligence.
Shall I take those two?
Yeah, in any order that suits you.
Yeah, so probably Client Earth first. I think it is a valid argument. I think that was ultimately Client Earth wanted, is to make a court consider the policies as well and how the board responded to it. But what the English courts try to do is they try to stay away from managerial decision. They look at Shell in particular as a very complex business, and climate change being only a minor part or threat of this in operations, and they would be hesitant to look into these disagreements around the policy between the shareholder and the directors unless there is some evidence that directors clearly did something wrong, something dishonest. So based on the some of the commentary that I read on Client Earth and speaking to the colleagues, I see that there was some difficulty in bringing the derivative claim, climate-related claim against the directors if the only issue is about whether policy is adequate or inadequate. I think you need to focus more on what the directors did or did not do, is whether they manipulated in some way with the evidence, whether they, for example, received some expert advice that they need to take more attention to climate change, but they didn't do that. So some of sort of dishonesty in that is probably required to bring a claim, a successful derivative claim. I also think there might be some success against the companies who climate agnosticists, so who completely deny climate change as a risk to their operations. That certainly could be a good ground for the claim. Speaking about tort cases, so one of the examples of the tort case on duty of care, as I've told you, is a case against Shell in the Netherlands. And it all comes, whether the case can be successful in other jurisdictions, is on little elements about how the law in particular jurisdiction operates. So one of the reasons why the Dutch case was so successful is Dutch civil code allows the courts to interpret existence of a duty of care quite widely. And one of the elements of that is the duty of care can arise if it violates unwritten standard of care. And this unwritten standard can be really broad. And in the Netherlands, in the Shell case, the Dutch court interpreted this as a standard introduced by the Paris Agreement, by the European Convention on Human Rights. So in a way, private duty of care was interpreted by reference to the international laws. You can't do this under English law. That's not how it works. And that's in the common law jurisdictions, quite different. And that's probably why we haven't seen many cases in England yet. Well, not many, but we haven't seen a similar case, a tort law challenge in England, even though we have quite a successful line of cases against multinational companies in relation to forced labor or cooperation with the police, for example, in some jurisdictions. But it's all all of these cases have been litigated in purely private terms. But I do know that there is that the lawyers in England are working on bringing some of those cases. So it might be we might see them maybe even this year.
Fabulous. So we have 2 questions left, and you are the lucky last 2. So we start. Would you please keep your question a little bit short because we're coming close to our time.
My question is again on director duties.
Yeah.
Just to understand that under the existing regime of director duties where obligations are currently just owed to the shareholders, barring certain exceptions where it can be owed to the overall stakeholders. Do you think that unless this regime actually changes, where the director duty is actually recognized by the stakeholder interest, future cases also kind of facing the same outcome as client or suffered before the UPI?
Thank you. Will you take 2 questions together?
Yes, maybe
Yeah.
2 questions.
So maybe
together.
the second question. Thank you.
Sure.
Thank you. Mine's quite quick. My question is that obviously we're seeing a rise in Australia, or at least a single case, and as Japan, in terms of actions concerning human rights law. I'm particularly interested in your perspective on why, up until now, historically, those types of actions have really seen a greater concentration in the global south, and why they're choosing to move away from, or at least bring rights, novel claims around human rights and constitutional law, as opposed to what is usually your company law, tort law, and more approaches.
Yeah, that's interesting. Great question. I'll first talk about client earth because it's rather, it's a bit more simple to answer. Actually, the way duty of care under Section 172 under Companies Act in England is construed, it says that in fulfilling a duty of care, the directors have to give regard to stakeholder interests, including environment, employees, consumers. But this have to give regard as something similar, have to take into account. This is not a very strong element, like have to take regard is if they said at the board meetings, okay, we have taken regard, like we facing environmental issues, etc. So have taken regard as if they talked about it, if they adopted a strategy, that basically means they have fulfilled this obligation. So if you want to have enforcement of those stakeholder interests, you need to have a bit more of a stronger phrase. And I don't think there is an appetite yet, at least in England, to introduce it. Speaking about human rights actions, it's a great question. I think it's ultimately comes to the comparative insights about how jurisdictions operate. So what I know from my previous projects is that first of all, there is environmental is in many jurisdictions part of the constitution, forms part of the constitutional protection. So you can bring actions not just protecting individual interests, how it's happening in many jurisdictions in European civil law jurisdictions, but you can actually bring a collective claim for the protection of the environment, and that's been allowed by the constitution. So this connection between protection of environment as a constitutional right and actually having an enforcement action gives rise to this novel claims. I did a project a few years ago. This that was on the slide about civil remedies and human rights. And when we talked about monetary claims, compensation claims in Latin America, what we learned is that litigants do not use tort law of delict at all because it's just not working. But what is working, they have lots of actions called popular actions under Constitution in Colombia, in Mexico, in Brazil, and you can bring this popular action as a mass action for the violation of the constitutionally protected right and sort of bridge this gap between public and private. So I think it's just the way the legal system works. It allows some different avenues to be used in those jurisdictions.
Actually, I see there's another question online. I'm interested in how fossil fuel companies are evaluated on the assumption that unrealised fossil fuel assets will be profitable. What do you think are litigation opportunities to target fossil fuel companies for risk of such assets becoming stranded with foreseeable changes to the market and government policy?
I have to say that it's a great question, but I probably won't be able to answer it right now. And that hasn't been the focus of my research so
No.
far, but it's certainly something I've written down and something that I will look at, definitely. So maybe at the next presentation, this is something I will be able to address.
So thank you to anonymous attendee for raising the question that will bring Ekaterina back to Melbourne when you've done that work and some other work
With
as
great
well.
pleasure.
Yeah, and look, this has just been the most magnificent seminar. Thank you so
Thank
much.
you so much.
And
I've learned a lot. I've had very interesting questions. Thank you.
Thank you, and thank you all for your active participation and really thoughtful questions. I'll draw this this seminar to a formal close, but you'll be able to talk to people
Yes,
afterwards
absolutely.
if you like.
If anyone has
So
questions.
please join me in thanking Ekaterina for coming so far and sharing her research. Thank you.